let's proceed from there.
Good morning, my lords. Your Ladyship. No, Your Ladyship. It was not 15 minutes, Your Ladyship. I had actually sought for 45 minutes, I think. Yes, Your Ladyship. No. Just for me, Your Ladyship. I must say this, my lord, perhaps before I proceed, that I have also noted that my senior Professor Ojenda covered quite a bit of ground. I will try as much as possible to be able to see whether I can condense that time a little bit. But we also have quite a bit to say in respect of Article 145, the fair hearing aspect. Yes, madam.
I introduced the students from Alliance in their absence. I think they are now here. You are welcome to participate in the proceedings of today. You can stand up so that we are informed that there are students from Alliance High School, members of the law club. You are welcome to this court. Thank you.
Permit me, Lord, to particularly welcome the students from Alliance High School, which is located in Kikuyu constituency, a constituency I had the privilege of representing in Parliament for 15 years. They are most welcome.
Thank you. Can have somebody from the state. State law office.
My Lord, Mr. Maru will start.
It's okay, I'll do it. Yes, you're welcome. We want to say welcome. We hope you'll learn from this. My name is Mercy Thanji. I work in the Senate, and I hope you'll learn something from this. You're welcome.
The leader Mwananchi group. Yes, thank you so much. On behalf of Linda Mwananchi, my name is Dave Anjiru. We wish to welcome you to these proceedings. We hope you learn.
Thank you very much. Now
Yes, my lord. Thank you very much, my lord. My lord, I intend, my lord, to submit on two issues that are at the core, my lord, of the petition that is before, the petitions rather, that are before this court, my lord. I intend to briefly cover some ground on, some additional ground, my lord, on the provisions of Article 145.3. That has been dealt with, my lord and my lady, quite a bit by my seniors, Professor Gidu Muigai and Professor Tom Ojenda. I'll also, my lord, deal to an extent with the question of fair hearing and the exercise of discretion, my lord and my ladies, by my client, the Senate, my lord. My lord, allow me to begin by looking at the character of the petition that was filed before this court, my lord, and the allegations that have been made with respect to fair hearing, my lord. I'll refer the court to paragraph 100 of the there's a number of petitions which have been, the first petitioner's further amended petition. This is the petition that is dated it must be the latest in the ones that is dated that is further amended on the 13th of August 2025, my lord. And my lord, the character of the pleading at paragraph 100 is important, and this is what it says. That second, as a second issue, belaboring under its misinterpretation, and this is the Senate, my lord and my ladies, of Article 145 of 145, the Senate imposed on itself and on the Deputy President an unconstitutional 10-day deadline to conclude the proceedings, my lord. This timeline is in violation of the Deputy President's right to fair hearing due to the unduly constrained timelines. Although, and this is important, although the Deputy President had elected to participate and was thus entitled to appear and be represented, my lord. There's then talk about a violation of the provisions of Article 145, Article 28, and my lords and my lady, Article 28 deals with the right to dignity. There's also an allegation of a violation of a right to freedom from cruel and degrading treatment under Article 29. Very specific pleas, my lord, in respect of the right to dignity and the right to cruel and degrading, the right against cruel and degrading treatment under Article 29. And the right to fair hearing by unreasonably denying, this is now the first petitioner, him an adjournment due to absence occasioned by illness. This is what, my lords and my lady, has been pleaded before this court. We submit, my lord, that the manner in which this pleading has been drafted then sets the background of a failure by the petitioners, my lord, and especially the first petitioner, to appreciate or conceptualize the right to fair hearing in the context of an application for adjournment before the Senate. Let me begin by saying this, my lords and my lady. The allegation with respect to the right to dignity under Article 28 has not been particularized. There is no specificity. There is no allegation in respect or a breakdown of the details of the violation under Article 28. But the same position is sustained with respect to the plea on Article 29, the freedom from cruel and degrading treatment. We don't have any particulars, my lords and my lady, on the violation as alleged. But it goes further, my lords and my lady. With respect to the right to fair hearing under Article 50, again, we don't have specifics of the provisions that have been violated. It is a blanket allegation of the denial of an adjournment, my lord and my ladies, on the basis of illness. My lord, it is now settled, my lord, that when alleging violations in the context of a constitutional petition, we must specifically plead and outline the violations which have occurred or alleged to have occurred. That has not been done, my lords and my lady. And I say this, my lords and my ladies, because in my very humble submission, that requirement is not ornamental. In my very humble submission, that requirement goes to the jurisdiction of the court to be able to entertain the petition. In the absence of details of the violations and how they affected the first petitioner, this court is then deprived of the jurisdiction to be able to then handle the petition in the manner that is framed. But in addition, my lords and my ladies, and now I'll take you to paragraph, I began with 100, I'll take you briefly to paragraph 99. The allegation that under Article 145.3 and 6 of the Constitution, by failing to form a special committee to investigate the impeachment motion, effectively, the first petitioner was then deprived of a layer of the fora availed to him for a fair hearing. I will come back to the submissions I've made in respect of paragraph 100. With respect to paragraph 99, and I will try not to repeat what my seniors have said, it is our submission that the role of considering and determining an impeachment, my lord and my ladies, is vested by the Constitution at Article 96 upon the Senate. And my lord and my ladies, the language in which this vesting is done is quite important. My lord, let me just make specific reference, my lord. If we go to Article 96, sub-Article 4, the role of the Senate, and this is very important for the Senate, my lords and my ladies. The role of the Senate under Article 96.4 is to participate in the oversight, my lords and my lady, of state officials. And how does the Senate, how does my client do this? By, and again, the wording is key, by considering and determining. By considering and determining any resolution, my lords, my lady, to remove the president or the deputy president. Considering and determining. Article 98, my lords, my lady, speaks to the membership of the Senate. And my lord, in a very peculiar manner, in a very unique manner, it sets up the Senate, Article 98(1)(a), as 47 members, each elected by the registered voters of the counties. B, 16 women members nominated by political parties. And C talks about 2 members, and D, and so forth. A very unique organ, a very unique body set up under the 2010 Constitution. This organ, this body was not in the previous Constitution. Read that together with 96, the role of the Senate to consider and determine any resolution to remove the president. Allow me, my lords and my lady, to then take you to Article 145, the much spoken about Article 145. And again, the wording is important. Article 145, sub-Article 3. Within 7 days after receiving notice of a resolution from the Speaker of the National Assembly. And A is key. The Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President. Now, very important again to the Senate, the convening of a meeting of the Senate. To do what, my lords and my ladies? To hear the charges. To hear the charges. My lords and my lady, I have tried to understand the meaning of hear under Article 145(3)(a). And I had a look at the concise Oxford English Dictionary, the 10th edition. Here's what it says. The word here implies that, just a moment, Melody, implies that the Senate seeks to adjudicate on the charges that have been presented. The words under 96.4 consider I will pause as, yeah. Yes, thank you, my lord. The words used in 96.4 consider and determine. Not just consider and determine any resolution to remove the president or a deputy president. My lord, the role under Article 96, as read with 145, as read with Article 98, is granted or bestowed upon the Senate, not a committee of the Senate. In fact, we submit that the use of the word determine under 96.4 demonstrates that the Senate is vested with autonomy and independent judgment with respect to the impeachment of a president or the deputy president. My lords and my ladies, we then go to the provisions of the second schedule, which I will not repeat. Professor Ojenda dealt quite a bit with that, of the second schedule to the standing orders. Just to point out, my lords and my ladies, that the standing orders are anchored upon the provisions of Article 124(1) of the Constitution. Under the 2010 Constitution, the people of Kenya felt it fit to anchor standing orders in the Constitution, unlike the previous Constitution, my lords and my ladies. And it then allows Parliament to make standing orders for the orderly conduct of its proceedings, including the proceedings of its committee. We then go to the second schedule. This is what takes us to the second schedule of the standing orders of the Senate, which then set out a very elaborate mechanisms. The heading is very important. It speaks about the rules of procedure when considering the proposed removal in plenary. There's a very comprehensive, there's a very elaborate procedure that has been set out under the second schedule. That is the procedure, my lords and my ladies, that was then relied upon by the Senate in exercise of its mandate under the provisions of Article 96.4, my lords, my ladies, and under the provisions of Article 145. Any submission, and I say this with tremendous respect to counsel for the petitioner, any submission to the effect that the impeachment process can only be conducted through a committee is in effect depriving, or an attempt to deprive or deny the Senate its role under Article 96. I urge this court not to allow such a position to sustain. In fact, and again I submit with humility, in fact, any such submission is absurd and illogical. So that effectively, and I will not spend too much time on this, so that effectively, if we read this in context, the use of the word may under 145B then allows the Senate to proceed either by way of plenary or by way of a special committee. Now, this is where it gets interesting, my lords and my lady. There has, unless unlike the challenge by the petitioners on the standing orders of the National Assembly, there is no challenge in the petitions before you on the standing orders under Schedule 2, the standing orders of the Senate under Schedule 2. Those standing orders are alive and kicking. They have not been challenged.
Just for the record, in our petition we have challenged them. Just for the record.
My Lord, I would not want to stray too much into Article 145. It has been addressed quite a bit by both senior counsel who came before me. I would not like, apart from just specifying to the courts the provisions and how they are worded, which I thought is important, I would then move on to the question of fair hearing. Now, my Lord, I have outlined when I began submitting how the question of fair hearing has been pleaded. And the reason I outlined that, my Lord and my ladies, was because there needs to be an understanding of how the Senate exercises discretion and whether that discretion then attracts a challenge under Article 50 of the Constitution. But I will begin by saying this. The process of impeachment under Article 145 and 96 of the Constitution is a sui generis process. It is a unique process. In fact, I submit that that process is both self-governing and self-executing. One does not need to look further than the provisions of Article 96, my lords and my lady, and Article 145, as read with the standing orders, to determine how the process of impeachment in this country is to be implemented or carried out. My lords, as submitted yesterday, the elements of fair hearing have been outlined in the Evans, Odhiambo Kidero, and four others versus Ferdinand Waititu case, my lords and my ladies. And it's a very, that case, my lords, makes very interesting reading on the question of fair hearing. It identifies two elements of fair hearing. My lord, one, an opportunity must be given to be had. An opportunity must be given to be had. Secondly, my lords, my lady, the opportunity must be reasonable. the opportunity must be reasonable. But what I found quite interesting in this case is that it then proceeds to cite a Ugandan case in the Court of Appeal, the Court of Appeal of Uganda. And my lords and my lady will have an opportunity to look at these in our submissions. Obiga versus Electoral Commission and another. It is our authority number 2. It is at, I think, at page 89. And this is what we found interesting. The Kidero case, in citing with approval the Obiga case, says this: in order to determine whether a party received a fair hearing, the court being the trial chamber, this is the context of a court, it's not even the Senate, but I quote it just because it is relevant to this matter. Being the trial chamber has to consider the statutes, case laws, and the regulations that inform the decision that the court made. You must look at the law that governs that process to determine whether the Senate then properly exercised its discretion. This court then has the task of considering the peculiar legal regime that governs impeachment process in making this decision. And I will try to briefly unpack how the Senate handled the impeachment proceedings against the first petitioner. And the first question that I ask myself is whether the opportunity to be had was fully accorded. Whether the opportunity to be had was fully accorded. Now, certain issues are not in dispute. That through a letter, and this is in our submissions, dated the 8th of October, the clerk of the National Assembly transmitted to the clerk of the Senate the resolution by the National Assembly to remove from office the deputy president. My lords and my lady will have a chance to look at the Hansard on this. The documents from the National Assembly were then forwarded to the Senate as evidence of the proceedings before the National Assembly. Subsequently, the Speaker of the Senate then, in accordance with Article 145, convened the Senate to hear the charges. On the 9th of October, the Senate considered a motion for the establishment of a special committee to investigate the proposed removal from office. Now, to perhaps calibrate the question of the opportunity to be had further, on the 9th of October, and this is not in doubt, my lords and my lady, the fourth respondent served the first petitioner with an invitation to appear and file his response to the allegations. An invitation was served. This is not in dispute. And is in accordance with the Schedule 2 of the Standing Orders. Now, similarly, and again, this will come out from the Hansard, the National Assembly was served with a similar invitation to appear. But what is important in the relevance of this matter, in this matter is this, that on the 14th of October, the office of the clerk of the Senate then receives a response to the invitation to appear. From whom does the response come from? A law firm by the name Swanya and Company Advocates. And it was very clear. It indicated that the petitioner had appointed the firm to represent him in these proceedings. Now, my lords and my lady, you will note when you have a look at the Hansard that at no point did this firm withdraw from acting for the first petitioner. At no time did this firm withdraw from acting from the petitioner. You will not see any document on record to demonstrate any withdrawal. But then it goes further. The first petitioner files fairly voluminous documentation before the Senate. These documents include the following, and this is quite important: the response to the allegations, a very elaborate response to the allegations. But further, the first petitioner files affidavits in support of the response to the motion that was before the Senate. We submit that to the extent that those documents were submitted to the Senate, the affidavits, sorry, my lords, let me just, the affidavits together with the response to petition. The Senate then, by that submission, the Senate then had the opportunity and the obligation to consider the contents of those documents. It is also not in doubt that the charges were read to the first petitioner. And effectively, and you will see this from the answer, the first petitioner responded to those charges. No issue was raised on the competence or the legality at the point the charges were read to the first petitioner. Now, again, opening statements were made by counsels on record, including, my lords, my lady, the counsel appearing for the first petitioner. We submit, and also important, we submit, my lords, my ladies, that the initial limb that was set out, that was established by the Kidere case, an opportunity must be given to be had, was then satisfied. In this manner, there was an opening statement by senior counsel, Mr. Ongoya. There was an opportunity granted to the first petitioner's advocates. And again, 60% of the Hansard is actually the first petitioner's counsel cross-examining. Of course, there was an examination in chief by the lawyers for the National Assembly, but also cross-examination, very in-depth, comprehensive cross-examination of the witnesses that were called by the National Assembly. Very elaborate. But also in addition to that, that limb was satisfied by the first petitioner filing a response to the particulars of the allegations, together with the affidavits. But also important, my lords and my lady, on the 17th, as the case was ongoing, and this is critical, perhaps for the Senate, the first petitioner was in person at the Senate. He was there. 15 minutes, Melody? Okay, let me see how to let me see how to reorganize my thoughts. But he was there, like I said, at all times. But it then gets very interesting at about 1:15 p.m. when the case for the second respondent, the National Assembly, is concluded. And a very interesting direction is issued by the Speaker of the Senate. And he says this, that upon resumption of the proceedings at 2:30 p.m., the fourth respondent would hear the first petitioner's case for 2 hours. And it's very specific, comprising examination in chief, cross-examination, and re-examination. This was a pivotal point in the proceedings. Like I said, throughout the morning session, the first petitioner is before the Senate. But when the proceedings resume at 2:30, and it is then time for the cross-examination of the first petitioner, my senior, Mr. Paul Muite, and the team of lawyers, very well-renowned lawyers, informed the Senate that they are anxiously awaiting for the first petitioner. In other words, I don't know whether to use the words of my senior, Professor Ojiambo, the first petitioner has vanished. He cannot be found. Now, senior counsel then proceeds to inquire where his client is. Okay? Now, we submit that at that time, my lords, my lady, senior counsel is making a request in the form of an adjournment. Because the Senate Speaker has given very clear directions on how the matter is to proceed. It is a request, bearing in mind that the directions were given in the presence of the first petitioner. It is like, my lords, when we appear before you and you direct us to appear at 2:30, and I walk in, normal civil case, and I do not have my client who is supposed to be cross-examined, I will be requesting, my lords and my lady, perhaps a minute or two to try and locate my client. That is a request for an adjournment. That request, my lords, my lady, was allowed. That request was allowed. And senior counsel then reports back and says, out of the blues, that he had learned that his client was ill.
I think you have written submissions.
Yes, I do.
So that you can give them.
I have written submissions. I am just highlighting those submissions.
The narration is you have already amply submitted on the facts.
Yeah.
Can we then move beyond that?
My lord, I won't take more than 5 to 10 minutes, because there's a point I'm making, my lord. And that's why I'm saying the application was for an adjournment. There's a reason that I would like the court to just appreciate the number of adjournments that were put in place.
What I'm thinking is that if we have the written submissions,
Yeah.
and we know exactly what transpired in the Senate,
Yeah.
and also part of the hindsight,
Yes.
then there's really no need to hash them over and over again.
Allow me, my lord, just 5 minutes. But I hear you, my lord. I stand guided. My lord, when Mr. Muite returns, he then informs the Senate. He requests that he be allowed up to 5 p.m. to try and meet his client. That is a second application for adjournment. Give me up to 5 p.m. to meet my client. Again, my Lord, that request for adjournment is allowed. That request for adjournment is allowed. When the matter finally is called out at 5 p.m., Mr. Mwite then informs the court that he had learned that his client is at Karen Hospital and he did not have access to him. My lords and my lady, between 1:15 and 5 p.m., no document is presented to the Senate. No document is presented to the Senate to enable the Senate then be able to exercise its discretion in favor of the first petitioner. My Lord, from the month of November 2024, the petition has been filed, it has been amended, it has been further amended. We only received a purported document through an affidavit that was filed in court last week. That is the only time that we receive a semblance of a document. But even then, my lords and my lady, that document is presented to this court for the purpose to enable this court to exercise the discretion that this court does not have. The first instance exclusive discretion, my lords and my lady, with respect to the question of adjournment was at the Senate. It is not at this court. This court does not have that jurisdiction. And my lord and my lady, this court, even if it is not agreeable, even if 1.5 years later, the first petitioner came and said, I was feeling unwell, this court cannot substitute the discretion of the Senate with its own. That discretion on the question of adjournment in that context is purely for the Senate. My lords, my lady, we have in our submissions made quite a bit of hay around the question of that discretion and why it was exercised in the manner that it was. And I'm sure, my lords and my lady, that you'll have a chance to read that and reach certain conclusions. I would distinguish, my lord, two things under Article 145. I would submit that the exercise of discretion in the context of the adjournment application is distinct from the exercise of discretion, in the exercise of the Senate's power when voting on the question of impeachment. The exercise of discretion gives the Senate sufficient latitude with the information that is before it, my lords, my lady, to be able to determine whether to adjourn or not. It is a discretionary power. I urge this court with utmost humility not to interfere with that power based on a document that was presented to the court 1.5 years after the impeachment occurred. My lord, my lady, in cross-examining Dr. Gikonyo yesterday, a number of things became apparent. Number one, Dr. Gikonyo told us he did not know why he was in court. Number two, Dr. Gikonyo told us that he did not know that he had access to the Senate on the 17th of October 2024. Number three, Dr. Gikonyo told us that he did not know whether the document was presented, the medical report or the affidavit was presented to the Senate. But one concession perhaps perplexed me quite a bit. The admission by Dr. Gikonyo that he did not know that he could get access to the Senate in the context of impeachment proceedings, I found personally quite startling, especially noting that senior counsel, together with a team of lawyers, would have made efforts in any event on the 17th of October to try and secure or procure a document from Karen Hospital, or for that matter, have a doctor attend at the Senate to demonstrate to the Senate in that context that Dr. Gikonyo was unwell. Sorry, that the first petitioner was unwell. It appears that there was no such effort if Dr. Gikonyo does not know that he could have access to the Senate. Didn't the 10 to 12 lawyers who are appearing for the first petitioner in the matter, were they not able to inform Dr. Gikonyo of that? But also of importance, my lords, my lady. Upon the Speaker making his ruling, or upon the Senate voting, on the question of a further adjournment, what did the lawyers for the first petitioner do? They walked out. They left. They left the Senate. No withdrawal, no document of withdrawal, nothing. They left the Senate. Now, my lords, similar scenario. You're seated as a judge. Counsel comes and informs you that there's an issue with the client, a witness. You rule based on the information or lack of information before you. And then Mr. Mukele walks out. I mean, it is remarkable. And that is why we are submitting that by having counsel from the beginning to the end, those lawyers ought to have sat in the Senate and dealt with the tail end of the impeachment proceedings on behalf of their client. What was staged, my lords, my lady, was a walkout from the Senate. My lords, as I wind up, my colleague will submit on a number of other issues, but as I wind up, I began by submitting that the Senate, the provisions under Article 45 are self-governing and self-executing. The court needs look no further than Article 145 and the standing orders to determine whether the discretion was exercised in the manner it ought to have been exercised. Even if, my lord, like I submitted, even if for any reason you may not agree with that exercise of discretion, you cannot substitute that discretion with your own 1.5 years later. And I say this, my lord, with utmost humility. Now, there has been an attempt by, I think it was Mr. Ndegwa, to refer to the Senate as a tribunal. As a tribunal. My lords, my lady, nothing could be further from the truth. The Senate is a constitutional organ in performing a constitutional function in a quasi-judicial manner. It cannot, in excess of that function, be, and I say this with humility and respect, be referred to as a tribunal. The impeachment function is an oversight function under Article 96 of Article 4. It is a peculiar and very unique function, my lords. My lords, as I wind up, I'm just being reminded by my colleague, Ms. Tanji, the question of timelines. A lot has been said about the question of timelines in the context of this matter, my lords. I've had an opportunity to participate in election petitions, my lord, and normally you are told that your petition has to be heard and determined within 6 months. My lords, that deadline is cast in stone. When you go outside, and the Supreme Court has said this, when you go beyond that deadline, then you then have a jurisdictional question in respect of the proceedings. Now, my lords, seated as a judge and I've appeared before my Lord Justice Ogola on an election petition many years ago. Seated as a judge, you then have to make the decision as to whether you want to hear this petition in the 5th month, on the 1st month, or on the 3rd month. It is a decision you make as a judge. Of course, lawyers will come with very many stories. I have a hearing in the Court of Appeal and all those things. But in election petitions, I know the judiciary has put its foot down and said, we are giving you a month to come and for us to hear and determine. There is absolutely no illegality, my lords, my lady, in that petition, the impeachment motion proceeding on the, I think, 16th and 17th of October. There was no illegality that was, and no such illegality has been demonstrated. My lords, in your ruling on the application to set aside conservatory orders, you reiterated the importance of the office of the Deputy President in the context of the current constitutional setup. That office cannot be left vacant. But even then, under Schedule 2, the procedures in plenary, the hearing of an impeachment motion has to proceed once it commences. This is Rule 12, Part 1. Once the hearing commences, it proceeds on a day-to-day basis. It proceeds on a day-to-day basis. It was therefore upon the Senate to ensure that the hearing proceeded expeditiously. My lords, my lady. We submit, in conclusion, as follows, my lords, my lady. Number one, that the Senate handled the impeachment proceedings in accordance with the provisions of Article 96(4) and 145 of the Constitution. We submit that the Senate, that the first petitioner was accorded both an opportunity and a reasonable opportunity at that to be had. I have submitted, my lord, already about the 3 adjournment applications and the 2 which were allowed. My lords, my lady, barring any clarification, I will stop there. I think I have kept within my timelines. We have filed submissions. We have an entire set of the Hansard, which I'm sure you will have a chance to look at.
Thank you. By way of clarification, on Article 145,
Yeah.
you appear to be departing from the submissions of both the petitioners and the respondents. You are not bothered with either shall or may. You are saying the competence belongs to the Senate.
My Lord, thank you for that question. It's a very important question. I have not departed from the submissions of the National Assembly. I have not done that.
No, they were concerned with
yes.
the application of shall or may.
Yes.
But according to you,
Yes.
you are not bothered about that. You are saying this is the competence of the Senate.
We two things. We are bothered in this manner, that I was trying to avoid repeating the submissions of Professor Gidumigai on the may or shall. I thought, like I started when I said, I didn't want to repeat again what they had said, because Senior Counsel Professor Gidumigai and Professor Ojenda have covered this issue quite elaborately. Let me say this, my Lord. So, first of all, I associate myself fully with those submissions. But in addition, we are saying, and I think I said it at some point, my Lord, that the may allows the exercise of the power by way of resolution. Yes, by way, allow me, my Lord, to go to Article 145, just to answer that question, as I associate myself with the submissions of my colleagues for the respondent. The may, under Article 145B, my Lord, the may, and based on my submissions, the may then gives the Senate the power to determine whether to go by plenary or whether to go by way of committee. So in addition to those submissions, this is what I'm saying. Okay? But as I wind up, my Lord, my Lords will have an opportunity to look at the provisions of Article 152, sub-article 7. This provision, my Lords, is important. It relates to the removal of a cabinet secretary. And this is what 7A says. Unlike 145, it says, the Assembly shall appoint a select committee. Under 152, there is no may. It is mandatory. If the Assembly does not appoint, the entire process, my Lords, my Lady, collapses. Under 145, the may, if they decide by resolution to go by way of committee, then that is how it is carried forward. If they decide not to, then under 96, my Lord, it then reposes upon the Senate to then hear and determine that matter. And my Lord, as I wind up, I know I have said that a couple of times, as I wind up, I'd also invite you to look at the provisions of Article 145. My lady, I know you're about to stop me. Article 145, sub-article 1. It is an entire process by the National Assembly, including the threshold for the supporting of a motion. Under 145.1, there is, I think, the 1/3. Under 145.2, there is the 2/3. Now, it cannot be the intention of Kenyans that a process that has come through the National Assembly with such threshold is then collapses at the Senate because of the may or shall. Because once it gets to the Senate, having achieved the 1/3 and the 2/3, then it is, the charges have arrived. So the Senate then has to opt as to then how to proceed. So the submission by my colleague, Mr. Ochiel, to me, just is absurd and illogical. It doesn't make sense at all. But it is for the court to decide. I hope that the court will be persuaded by our submissions in this regard.
Thank you.
Any other questions, Madam? No? Thank you. Thank you, my lords. Thank you, my lords. Thank you for listening to me. I don't think, but that hour included.
15 minutes were cheated through by your colleague.
But also, there was a very important question which you asked, which I answered for 10 minutes. So perhaps that would go to.
Yeah, but my lord, the rule was that we should set good examples to the students at all given time.
Yes, right. My lord, because my colleagues have covered quite a bit of ground, I will try and save time. I'll be very brief. I want to. I'll do 20 minutes. Yes, I will try. Yes, thank you, my lady. So I also want to add to what Mr. Mukele has spoken about on timelines and highlight a decision of the Court of Appeal, Civil Application number E121 of 2021, Attorney General versus Tolfin Nafula and others. And on the question of timelines, this is what the Court of Appeal had to say. We think, with respect, that courts should endeavor to facilitate obedience and observance of constitutional bounds and statutory timelines. The court then proceeds to say, in the case at bar, it is urged that Yes, Mr. Mukele is taller than me. Yes. In the case at bar, it is urged that truncating the interview and nomination process for the Chief Justice and eventual appointment will lead to an overshoot of the statutory timelines with a real and present danger of a constitutional crisis of the character adverted to herein. We are not persuaded that we should actively aid and abet such a result. So, my lord, my lady, on Mr. Mukele's submissions that the Senate was bound by the timeline set by the Constitution and the standing orders, we are asking this court to also allow and uphold that decision that the Senate took to adhere to the timelines and to make an expeditious decision. And there was also a danger of a constitutional crisis, as in the Tolfin Nafula case. It was important that the matter be resolved expeditiously. And the question of expeditious disposal also came up in the Sonko case. And at paragraph 134 of the Supreme Court decision, the Supreme Court reviewed the timeline set out by the standing orders, and they found that the Senate had an obligation to adhere to those standing orders. And at paragraph 135 of that decision, the Supreme Court also finds that expediting the process of impeachment does not in itself amount to a breach of the rights of Sonko, Honorable Sonko at the time. They found that he had been given sufficient time within which to prepare and present a response. And my colleague has taken you through everything that transpired in the House. So I move to the question of public participation. I'm glad Mr. Masharia has joined us. He was the chief, I want to call him an offender, but I'll call him a proponent of the way the Senate should have conducted public participation. My Lord, yesterday you asked the question of what is case-by-case basis. It's because Parliament does not only do bills, there is other business that transpires before Parliament. And in each case, Parliament determines how to handle public participation in this matter. So it is true, Article 10 and Article 118 place that obligation on Parliament to conduct public participation. And in the Sonko case, but now the Court of Appeal decision, which was subsequently upheld by the Supreme Court, the Court of Appeal says first, it is for the government agency to determine how the process will be carried out. Sorry, it's at paragraph 42 of the Court of Appeal decision. It is for the government agency to craft the modalities of public participation and to take into account the quantity and quality of the governed to participate in their own governance. And Mr. Kipkoge also spoke to this yesterday, that facilitating, affording an opportunity for the public to participate does not mean that we must compel the public to submit. Therefore, the submissions on 0.1, 0.04, 0.14, they do not arise. What matters is, were the people aware that this process was going on, and were they afforded as a sufficient opportunity to participate? Now let's come to the Senate. The Senate is sitting as a trial court. They are sitting to consider the evidence, the facts. They are sitting to listen to the lawyers. It is different from the process in the National Assembly. The process in the National Assembly is when the motion, that is when the motion is now being taken out to the people. And they did that. They went to every constituency in this country and provided the people with an opportunity to understand what was before the National Assembly, and which will later come to the Senate, and they asked them to submit their comments. But when the motion now comes to the Senate, the process changes. It's now sitting as a trial court. It's also why that's when the lawyers checked in. That's when the rules of procedure, the rules of evidence were introduced. And if you observe the process that the National Assembly was undertaking, specifically at Bomas, you will see a level of catharsis for the public. That's why they were saying tupewe chakula tushibe. That process should not happen like that in the Senate. The Senate must sit as a sober court and listen to what is before them on the facts and the evidence. Then the second thing that the Court of Appeal says is that there should be innovation and malleability on the subject matter, culture, logical restraints, and so forth. The petitioners are saying that the Senate should have gone back to every constituency or every county in this country and done the same process that the National Assembly had done. And they're disregarding that there was a process, and those documents from the National Assembly were presented to the Senate. Thirdly, the program that is fashioned for public participation must include access and dissemination of relevant information. My colleague, Mr. Kipkoge, has informed the court, and it's on the record, that these documents were widely publicized. They were availed at the constituency office. They were on the website. There was an email address, and there were physical sittings where members of the public could participate. Now let's come to the Senate. What is the Senate required to fashion in such an impeachment proceedings? One, it's that these proceedings must be open to the public. The motion must be made available to the public, and if they want to attend, depending on logistical constraints, they should be allowed to attend. My lords, my lady, you will see from the Hansard that this was done. These proceedings were public. They were members of the public were also allowed to attend. It was televised. It was on the website. There's a YouTube page on which Senate proceedings are aired. And the voting, the decision, the discussions that the senators undertook, the submissions by council and by the National Assembly, they were all open and available to the public, including the request for adjournment, and including the final vote where the House decided to proceed. All that was public. None of it was done in secret, and therefore the allegation that the Senate did not do public participation is not correct. Then the Court of Appeal proceeds to say public participation does not dictate that everyone must give their views on the issue at hand. This goes back to Mr. Masharia's submission on 0.014%. The numbers do not matter. What matters is what was done. Did it reach every single person in this country? Were they aware of what was happening? And I will say that from the efforts that the Senate made to make sure that everyone, and it's televised and it's on the website, that is public participation in the context of an impeachment of a Senate sitting as a trial court. That is public participation. And finally, and most importantly, the right of public participation is not meant to usurp the technical or democratic role of the office holders, but to cross-fertilize and enrich their views with the views of those who will be most affected by the decision. this is important because the Senate had received documents from the National Assembly and from the petitioners, and what was required of them is to make a decision based on the material before them, the grounds before them, the evidence before them, and make a finding whether it had been substantiated. So it matters not that there is a section of the country that did not agree with the process. What matters was what was before the Senate, and the senators were required to make a decision based on the evidence, and they did make a decision and found that there were grounds that have been substantiated. So, my Lord, we are saying that what the petitioners are arguing, that there's one brush for both houses of parliament, in this case is not correct. And on the question of case-by-case basis, we are saying that when the Senate is sitting as a trial court, the public participation looks different from when the Senate is undertaking its legislative mandate. And because at all times the proceedings, the debate, the documents were available to the public, there was public participation. And there was also a submission from Mr. Macharia again, that the Fair Administrative Action Act requires public participation, and my colleague has submitted that this is a constitutional function. This is a House of Parliament sitting to discharge its constitutional function of oversight, and there are proper parameters that apply for public participation. Then, my Lord, I'll move to the next issue, that there was an allegation from the petitioners that there was new evidence and witnesses allowed to submit to the Senate, which made the process unfair to the petitioners. My lords, my lady, you will see from the Hansard, the Speaker did give a ruling on this matter, and he referred to Rule 7 and 8 of the Rules of Procedure. The Speaker finds that Rule 7 and 8 permitted the Senate to receive witness statements, list of witnesses, and any other evidence. The Speaker then proceeds to say, what is not allowed is to introduce new allegations or introduce evidence that is extraneous to the allegations. And based on what had been presented, the Speaker ruled that the documents were permitted under the Rules of Procedure. They were provided to the petitioners, they had a chance to respond, and so that issue that they were unable to proceed with their case or it affected their fair hearing is dispelled by that communication by the chair. It's in the Hansard which we have provided to the court. My Lord, the final issue which I wish to highlight on is the Speaker of the Senate has been accused of bias because he was a member of a political party or a coalition. If you look at Article 106 of the Constitution, for a Speaker to qualify to be appointed as Speaker, you must qualify to be appointed as a Member of Parliament under Article 99(1)(c). What this means is either you are nominated by a political party, or if you are an independent candidate, you are supported by at least 2,000 registered voters in the county. So definitely, the person who becomes Speaker is someone in the political realm. However, when they do become Speaker, under Article 107, their role is to preside over the House, and under Article 122, the Speaker has no vote. Even on the adjournment, he had no vote. He had to put it to the House and leave it at that. So when the petitioners allege bias just by virtue of the fact that the Speaker was active in politics, there is no evidence. There's nothing that has been produced to show that the Speaker did or did not do anything that was required of his role. And my Lord, we ask you to throw out that ground of the petitioner's submissions. Finally, my Lord, if you look at the Hansard, there was equal time allocated to both parties, both the National Assembly and the petitioner or the respondent in the Senate. They were allocated equal time. So they have alleged that there was no equality of arms. That's not correct. The Hansard will bear us witness. that they were given the same time as the National Assembly, and it was up to them to organize their case and how they would like to proceed. Therefore, my Lord, we ask that you dismiss the petition. Yeah. Thank you.
I've heard from other submissions
Yes.
from the team
Yes.
that indeed Senate is not obligated to do public participation.
Yes.
From your submissions, I gather that you are saying that
Yes.
in fact there was public participation in the Senate. Can you please clarify the position of the team?
Yes, my Lord, the position is we are bound, the Senate is bound by Article 10 and Article 118 and complied with that requirement. What we are saying is the obligation is not the same as the obligation on the National Assembly, but there is a requirement and there was compliance. I don't know if I've
So
answered.
the submissions by a part of the team that
Yes.
the Senate is not obligated at all, it's not erroneous.
Not erroneous, I'm qualifying that the Article 10 and 118 require that we facilitate the public.
So you are departing from that submission.
I'm qualifying, my Lord, that that obligation is conducted in that manner. Yes, yes, thank you. That is the correct position. Yes, thank you.
My lady, we had prayed for 2 hours. We crave your permission to give us that time. I had earlier on said my client is perhaps the one that stands to lose out of this process if this petition should succeed. There are a number of allegations made against him. That is the context, my lady, in which we had sought for that time. And as
Just for the sake of good order, we note that we appear as respondents, and Muthomi's client is an interested party. If there will be no issue with him proceeding, then we have no problem. We can proceed as long as the court is aware of that arrangement.
Do you prefer a particular order of proceeding? You want to come before?
No, he may proceed. I just wanted it noted that we are still pending his response.
Thank you very much, my lord.
Mr. Kamota, I think by yesterday you have not filed submissions.
Why don't we already filed our submissions a while back? Our submissions are dated the 24th of April, 2026. They are there.
Do you feel prejudice if Dr. Campbell proceeds?
There will be no prejudice in my view. In fact, I suspect that we make my work easier by 98%.
All right. Thank you. Proceed, Dr.
Thank you very much, my lord. My name is Muthomi Nkolu. I appear for the second interested party, that is His Excellency, Professor Kithure Kindiki. I am joined by Mr. Moses Kipkogei, Kennedy Meli, Steve Ogola, Boniface Mwereru, and Kenson Mutethia. In that representation, for today I'll be sharing the time with Mr. Kenson Mutethia. For the record, my lord, we filed the following documents, which we urge the court when you retreat to peruse. One of them is the replying affidavit sworn by His Excellency Professor Kithure Kindiki on the 20th of February, the year 2025. We have, in addition to that, filed submissions dated the first day of October, the year 2025. Number 3, we have filed a list and bardo of authorities, also dated the first day of October, the year 2025. And lastly, we filed an affidavit dated the 8th day of May, the year 2026, in response to the issues raised in the affidavit filed by Dr. Gikonyo. My Lord, I have reflected quite deeply on the matter before the court for the last 2 years, and I have not been sure, perhaps because age is catching up with me, whether the petitioners actually believe in the allegations they have brought to you. But in the course of that reflection, my Lord, and in the course of practice of the law in cases like the one before you, it has occurred to me that it is quite easy in a dispute like the one you're now hearing to lose sight of the real issue. You know, lawyers come in their various grandeur and sophistication, and they say 1,000,001 things. And in that forest of very many things, allegations and counter-allegations, my experience is that it is easy to lose sight of the real crux of the matter. And to me, the real issue, my Lord, may be formulated in 3 ways. One of them is whether the courts...
Naam, bila shaka mpenzi mtazamaji, kumbuka ni picha za moja kwa moja kutoka kwenye mahakama ya Milimani, ambapo kesi ya yule aliyekuwa naibu wa rais Rigathi Gachagua ya kubanduliwa kwake inaweza kuendelea. Hivyo basi kumbuka kwamba ni mawakili wa yule ambaye ni Rigathi Gachagua ambao wanaendelea kuwasilisha hoja zao, na hivyo basi tutakuwa tukirejea pale kwenye mahakama ya Milimani. Lakini kwa sasa niruhusu tu niweze kukupeleka ama kufululiza moja kwa moja hadi katika kaunti ya Mombasa, ambapo afisa mkuu